Mr. Vyas, I must say, he is quarantined. He can't come.
You will address, yeah.
I will address. Because since your options are fixed today, on the request.
Yes. No, you argue. You are appearing for
Corporation.
in LPA 193.
Yes,
Ah,
both.
Both.
But this is cross appeal. You know, I filed an appeal, corporation, because the London single judge has imposed a cost on the corporation, allocate of 25,000, while dismissing the petition. Petition is filed with them, because it is dismissed.
It was not dismissed, my lord.
Anyway, it was, while disposing of, my lord,
so you are agreed only to that extent.
cost
Cost.
So far he is concerned,
He is agreed by the dismissal itself.
My lord, he has argued the case previously in the previous bench also in the same petition.
So we should not hear today.
No, he is welcome. That's what I beg.
All right. What is your case?
Thank you, sir.
Cut this. Court master.
My lord, this is my singular honor to appear before the senior most bench of the Gujarat High Court. Kindly accept my gratitude for accommodating my request yesterday. My lord, I am not into judicial activism. At the age of 70, standing here in visible pain and discomfort, I do so because our very existence as an entity is threatened. We are at the brink of bankruptcy by virtue of the illegal demolition committed by the respondent. My lord, they simply bulldozed the entire structure without adequate opportunity for us to vacate, and I'll present it. I wish to remind your lordship that the previous benches, partly by reason of my being a party in person, perhaps they have been very gracious to me, and I hope that my lord will also accommodate a bit of indulgence by letting me present all the facts first and then cite the evidences.
Mr.
Jauhar.
Mr. Jawar,
Yes, sir.
we will completely grant you opportunity to address your argument. But that doesn't mean you are Mr. Mohammed Hassan Jawar,
Yes, sir.
right?
Yes, sir.
But that doesn't mean that you keep on arguing what you have argued, repeating number one,
Yes, sir.
and going hither and thither your arguments.
Yes.
Stick on to the issue involved in your petition.
I will do that. I'll do my most, sir.
Yes. Now you are filed this letters patent appeal 434 of 22,
Yes, my lord.
challenging the order of the learned single judge.
Yes, my lord.
Where is that order of the learned single judge?
Judgment is SCA, Annexure A, LPA, paper book, page number 24, my lord.
Yes.
Right on the page number 24, that's where it concludes. SCA page number 79, running page. That's where the judgment concludes. If I may read out the highlights of the judgment, my lord. His
Wow.
lordship, the
One
learned
second.
single judge,
Yes.
highly admired our work in his observations. He called this demolition as unwarranted and unfair. He chided the respondent and awarded special costs of 25,000 rupees. So in normal course, we should have been happy with it. But my lord, in substantive terms,
Come to page number 70, read from paragraph 5, 70.
Yes, my lord.
From the submissions made by the respective learned.
What's evident petition known as a society, the patch of green land with an intention to promote, requested the order with the jurisdiction to allotment of.
While reading, you should read every word. Don't skip, jump, right? You may be knowing, but we should know.
May I read paragraph 5?
Yes, from the submissions made by the.
What is evident is that the petitioner trust, known as Society for Promoting Rationality, in order to set up a patch of green land with an intention to promote the activities of recreation, requested the then order within whose jurisdiction the plot fell for allotment of land of plot to set up a park and other recreational activities. Accordingly, by a communication dated so and so, that is 6/5/1/2004, the plot was allotted to the petitioner. By further communication dated September 2004, it is specifically provided the society would not be in position to carry out any civil or permanent structure, but utilize the plot for extracurricular activities such as yoga, etc., so as to promote communal harmony on the plot, which was situated in the Juhapura, Vejalpur area. The letter clearly stated that the plot will be put to use after order carries out fencing, demarcation of the land, leveling and processing. The condition on which the plot allotted was tenure was for 1 year. It has come on record through the averment made in the petition that it was in January 2006 that possession of the plot was given by order. If I may remind, this was after the 1 year
You
expired.
first read it, then you can.
And the activities of the plot were set into motion by being formally inaugurated by the then governor of Gujarat in presence of chairman of order. That's the end of paragraph 5. Do you desire me to read further, sir?
Yes, yes, complete the. You want.
It is also 5(1), subparagraph 1. It's also a matter to be noted, and which is part of the record, that from time to time funds were given by various agencies, including grants from the members of parliament, for setting up certain infrastructural facilities like bore and water supply. Electricity connection was offered, and so was water connection by Vejalpur Nagar Palika. 5(2). Through the correspondence and record that Mr. Jauhar has annexed to the petition and drawn the attention of the court, it is evident that for the first time, it was in October 17 on the plot. Vesting with the Ahmedabad Municipal Corporation, the corporation asked for certain documents that petitioner would come forth and show necessary evidence of the usage. Notices of October 17 and November 17 was pointed by the corporation that the lands vested with authority for the purposes of reserve for garden. The petitioner was called upon to produce necessary evidence and permissions of continuing the possession and or allotment. Time was given that in the event it failed to produce such evidence, it should stop the use of land and hand over the possession. This is evident from various notices of the corporation dated 17/10/17, 11/17, 20, 11/17, 3-18, which specifically gave 7 days and 3 days time to the petitioner to vacate the land. In the interregnum, as it is evident from the communications addressed by the councillors of the AMC, that a recommendation was made to the mayor of the AMC to regularize and enter into a long-term public-private partnership with the petitioner society and continue the retention of the land with the petitioner as it was being used for the extracurricular activities, and the residents in the vicinity were happy with the usage of the land and the usage that it was put to. Lot 5(3). Also on record are the letters of the corporation asking the petitioner whether it was willing to accept PPP offer and regularization of allotment. From a letter dated 28 February 18, which is on record, it's established that the director of Parks and Gardens, another wing of AMC, had sought details and consent of the petitioner on the question of PPP, and the petitioner is willing to do so. The petitioner society, by letter of 20 March 18, accepted the PPP offer. So this consent was sought by the wing of AMC along with forms on 28 March 18. That was accepted by the petitioner. Despite reminders, nothing was done by the corporation to get back whether such a PPP offer was accepted. Having done nothing for over a period of over 2 years, the corporation again swung into action by eviction notices dated 1/1/20 and 28/1/20, asking the petitioner to vacate forthwith. Having failed to do so, and despite a request for time to vacate, looking to the vastness of the project for 15 years that it had undertaken by virtue of construction of makeshift auditorium and equipment, the petitioner requested for 3 months' time to vacate. On 25 February 20, the AMC issued a notice to seal the park. The request of the petitioner, therefore, of vacating and the time asked for was not accepted because it was prevented from vacating. It was prevented from vacating by virtue of the authorities having sealed the park on 26 February 20. In the interregnum, due to the ensuing pandemic, a request was made by the petitioner to the authorities to see that the goods that have been removed may be taken care of, and damage that was done in as much as the park remained unprotected, causing pilferage of large-scale materials from the site. Ultimately, on 4th June 21, the demolition was carried out and the goods shifted. 5.4. Admittedly, therefore, through the letter of authority, allotment specifically states, though the letter of allotment specifically states that the plot of land, namely, so it's FP 220, actually it should be 220, was reserved for gardens and was allotted to the petitioner for a period of 1 year. The same effectively was handed over in the year 2006 to the petitioner. There appears to be no complaint on the part of authorities which owned the said plot as far as its usage was concerned for a period of 13 years from 2004 to 2017. In October 17, the AMC sprung into action, asking the petitioner to come forth and produce necessary evidence for continuing the possession for land in question, which was reserved for gardens. Communication was exchanged inter se between the petitioner and the corporation, which indicate that what was contemplated was at the hands of the petitioner, that it was willing to enter into public PPP with the corporation in carrying out activities for which the plot was reserved, that is for the garden. The corporation itself had in principle agreed to it. However, it appears that nothing was either done on behalf of the corporation nor the follow-up was made by the petitioner so as to the status of arrangement that was entered into PPP and the memorandum. Then 5. On 25/2/20, the corporation sealed the park pursuant to the notices issued in January 20. And when a request was made by the petitioner for some time to vacate the land, admittedly from the time when the park was sealed in February 20 to the time when final demolition was carried out on 4th June 21, majority of the period, as can be taken judicial notice of, was a period when the state and country at large were undergoing a wave that was popularly called the second wave of the pandemic. Neither of the parties, therefore, namely the petitioner or the corporation, be faulted with not acting on the PPP or MOU or having given them the timeline to vacate. The averment in the affidavit, therefore, that the petitioner did not vacate the land which was initially given to them, and on a request for 3 months, the implementation had to be carried out because 16 months thereafter, the land was not vacated. From the credentials, 5.6, my lord, from the credentials of the society and the work that it carried out, it is evident that though no right vested in the society to continue with the possession of the land in as much as it was initially given for a period of 1 year, with the passage of time, it retained the right, no right vested in it. The subsequent correspondence between the corporation and the petitioner society would indicate that there was a tacit agreement that in the event the petitioner was willing to enter into a PPP to continue possession with the land for which its use was already being put to, that's for garden, the purpose for which it was reserved, AMC having waited for 16 months, namely February 20 through June 21, possibly because of the pandemic, carried out large-scale destruction of the structures on the land in question. The photographs evidencing that are on record. Sixth,
Yes.
Prima facie, would you want me to continue, sir?
Yes.
The nature of prayers made in the petition would indicate that the act of demolition, carrying away of properties, the exchange of correspondence inter se, and the prayer for damages and restoration of property would require a detailed fact-finding inquiry and leading of evidence, which this court may not be able to undertake with the restriction and permissibility in exercise of extraordinary jurisdiction under Article 226 of the Constitution. 7. This court, however, based on the exchange of correspondence and the pleadings, would certainly opine that when the petitioner society, with its laudable credentials, as put into the pleadings, was allotted a parcel of land by AMC order for carrying out the purposes of creating a recreational facilities, which it did, that it put up such facilities with the help of the authorities, is evident. Grants were received from MPLAD funds. The Vejalpur Nagar Palika gave water connection, electricity connection, albeit the petitioner continued to remain in possession for over a period of 13 years, despite the currency of allotment being initially for 1 year, may not give the petitioner a vested right to occupy the land. However, when the petitioner was asked to give details of the rights on the basis which was occupying the land, the reasons are known to this court. The notices of eviction were issued, and when a notice timeline was sought for vacating the land and putting in place the possession and return to the AMC, possibly due to pandemic in question, neither did the petitioner vacate the land, nor did the corporation exercise its coercive force to get the petitioner evicted. After the ebbing of the second wave, the corporation swung into action, demolished the properties and equipment of the land with the Muskan Park once stood. On the issue of the petitioner of the corporation entering into PPP, the question still remains unanswered. Para 8. From the eviction notices, it is evident that the case of the corporation is that the final plot is reserved for gardens. This court cannot shut its eyes to the documents placed on record, which would indicate that it was being used for the purposes of the garden and other recreational facilities, as is evident from the photographs and the communications on record. These facts are not facts which would deter this court from not exercising its right under Article 226 under the guise of being disputed question of fact. The fact is, as is evident from record, that the land was already being put to use as a garden. Though the allotment was made for a period of 1 year, the plot continued to remain in possession of the petitioner for a period of 15 years, though without any rightful occupation. The organization that carried out these activities deserve better treatment. In context of the prayers, that it was meted out shabby treatment in terms of carrying out large-scale demolition of property and causing loss to the tune of several crores of rupees is a question which would require a detailed fact-finding inquiry and leading of evidence. Paragraph number 9. The court will rest its case here. The plot in question, admittedly, till date is being reserved for a public garden. In the event the corporation still wants to use the same for a public garden, as it is so made out in the affidavit in reply, and the event and the petitioner is willing to enter into a PPP, the parties can enter into such an agreement for carrying out the purposes for which the plot is reserved. As far as legality of the eviction and the manner in which it was carried out, it is evident that the timeline was sought for vacating of the premises which the corporation had not granted, or maybe could not get the same vacated for a period of 16 months because of the pandemic. However, that it suddenly swung into action as a state machinery and demolished the large-scale structures, causing damage to the property of the petitioner, was unwarranted. However, the fact that the petitioner had to vacate the society as the society was overstaying its tenure is evident, but the manner of eviction was unfair. 10th. With these observations and with the liberty to the petitioner to approach the appropriate court for seeking damages of the action that the corporation has caused, this petition is disposed of, with a hope that in the event, irrespective of the unfolding preceding events, if the corporation wishes to undertake the usage of the plot, which is already reserved for gardens, and if the petitioner trust is willing to offer its services, the entire issue be reconsidered and a fresh allotment of the plot for usage of garden in the hands of the petitioner through a PPP be accordingly considered, if it is possible, in accordance with law by the corporation, particularly looking to the credentials of the society, which undertook the onerous task of using the property for encouragement of such activities. The petition is disposed of accordingly with a total cost of rupees 25,000 that may be paid by the corporation. Rule is made absolute to the aforesaid extent.
Yes. Yes,
May I, my lord, with this background?
yes. We have understood the background now. You were given a land of 200 square meter in the year 2004. Correct? 5/1/2004 to be used for your sports and exercises.
Yes.
And you are asked to keep that land open for children of all the communities. Not only to you, but also the land surrounding this.
Jim, my lord. My lord,
So
shall
you
we-
seem to have built a compound wall
No, they made.
for a
differences.
garden.
My lord, may I actually present the evidence? If your lordship may refer to page number 158,
Yes,
annexure in the paper book 7,
150.
158.
Yes, Photographs.
My lord, this is the, on the topmost left is what we got. And then you see it on the right, a bus service was specially set up for visitors to the park because the bus service, my lord, is run by AMC itself. So AMC was so pleased with our work that they set up a bus stop right at the gate of the park and launched a new bus service. The photograph number 2 and 3 show the extent of greenery and the toys we created. Photograph number bottom left, this is where we united the communities. This may not, I beg to remind you that Juhapura and Vejalpur have been kind of had dubious distinction of communal sensitivity, and we set this up right at the border to connect the communities because we are in the business of demolishing borders. This is why we did. You could see the activities on the next page. This is what we built, my lord. And Hindu children and Muslim children and school children from all over Ahmedabad used to come and connect. My lord, throughout 13 years, throughout 17 years, as a matter of fact, till date, AMC has not alleged any violation by us. They have not accused us of any wrongdoing or deviation from the purpose of allotment, etc. We were promoting science, we were promoting communal harmony, yoga, health for elderly, page number 160, as you might see, my lord, providing free treatment to the elderly. So it was not a patch of green in the conventional sense, it was a multi-purpose park. And my lord, page number 161 shows the inauguration ceremony. This inauguration happened 1 year after the expiry of the alleged allotment. So the entire argument that it was allotted for 1 year stood infructuous by de facto actions of the corporation. I will, my lord, at the bottom of page number 161 is the photograph of the mayor of AMC. It is 2010. That is 6 years after the inauguration. We built an auditorium, flooring of which was funded by the MP grant, Mr. Advani's grant, routed through the same corporation 4 years after the alleged expiry. And Mr. Mayor here has made a public offer to us, offering 2 more plots of land, which we politely declined. We said, sir, we are not in the business of making parks. This was a model park we set up for the society. And
Why did you build an auditorium?
Auditorium for training yoga, life skills. We were required to, if I may take you to letter of allotment, my lord, letter of allotment itself.
Yes, 5th June, page 65B.
Letter of allotment, my lord.
5/1/2004. Page
Yes.
number 65B.
Thank you so much, my lord. That's the typed copy. My lord, there are 2 letters. That's very interesting. And it's important for me to draw this clarity.
First allotment is 5/1/2004.
My lord, the first letter is of January 2004. And it's important. In fact, in the communications of AMC, they have referred only to this letter largely. And this letter, paragraph number 4, straight away, the authority may discontinue the use of the plot at any time without notice when the need arises for this plot.
Now come to 66B.
My lord, I was trying to submit that this paragraph has been deleted in the subsequent allotment.
That is right. It is in page number 66B.
Yeah, 66B retains one term of 1 year, but it clarifies. And actually, if I were to be permitted to give the background, you would then understand. But I'll read the letter as you have directed me to read. That if the authority comes to know of any commercial or illegal use of this land, it may immediately stop its usage. So now they have provided a mechanism how they can stop the allotment.
Where did you read?
Last paragraph number 7, my lord, 66B.
No, you read the full letter.
Full letter? Yes, my lord. The first para. With regard to the above subject, your organization is allowed to use the land in the above location under the following conditions. Second, no civil or permanent construction can be done in this plot, and we have done none. This land is allotted for use by the people of all communities for sports, exercises, as well as for non-communal cultural activities. I'm sorry, the Gujarati word was bin sampradai, which could mean both secular and non-communal. I had to be very guarded in submitting the translation to you. The Spratt organization will not have any right of ownership of this land, nor will it be able to claim, allow me to submit, sir, that we have never claimed the right of ownership, and we have in fact displayed a notice that this land is the ownership of AMC throughout. Paragraph number 3. Order has full authority to grant the land attached to this plot. There was additional land attached to it, which could have been allotted to us, but they declined and we accepted that. Order number 4. Spratt will only be able to move its equipment after order completes demarcation of the land and fencing at this place and completing the work of filling, leveling and pressing. And this process took longer than 1 year. So the possession itself was given to us after the alleged expiry. Therefore, when I protested to order chairman, the then chairman, that said this 1 year condition was not the understanding was for 30 years. He said, and I quote, he said, Mr. Jauhar, this is how it works. You are given a clause. A clause has been indicated to provide for termination, and that clause has been removed. And sir, I am maybe pleased to, maybe your lordship may be pleased to learn. He then wrote a letter, the then chairman of order, after 13 years when the notices were issued, he wrote a letter to the corporation mayor confirming his agreement, understanding, and that letter is on record. He said, yes, this letter was given, this allotment was given for long term, and this letter, along with the letters of 6 councils, all the 6 councillors of that area, of both the political dispensations, wrote to the corporation to regularize the park, saying that the park is doing wonderfully well. So here is the situation. I may be permitted to draw the distinction between the de jure and the de facto. On the one hand, they cite that the term of 1 year throughout, but they do not recognize the fact that the possession was given after 1 year, inauguration happened after 1 year by the first citizen of India, and then the grants of MP were routed through the corporation after 1 year. Assuming that because they remain the owner, and which we acknowledge, therefore they have the right to ask us to vacate. But when in 2017, it became clear to us that there is no more goodwill and no love lost between us and them. We said, all right, if you don't want us to serve, because we had invested heavily, they led us to invest. I hope your honor will recognize, your lordship are recognizing that all that they give us is land, all the investment, building, the superstructure, not the civil structure, there was no superstructure, all the trusses, auditorium, science gadgets, habit, because it was supposed to be a multi-purpose hobby center. All of that worth several crore rupees was funded by us, and they led us into doing it by their action. I am sure your lordship will not let them go away scot-free by the technicality of 1 year, which they repeatedly ignored. They allotted a water connection 15 years after this. But something happened after 13 years that has political connotation, therefore I'm not submitting it.
Now, what has happened to that land?
The land continues, my lord. It is meant for a park. They can do nothing but set up a park.
No, what is it? They are now there a park.
No, sir. They have removed our assets and the land is lying there. My lord, this was not.
Park is not established?
No, sir. They will allot to somebody. Probably they didn't like our name or our face, whatever they want somebody else to run. But not a single paper, not a single telephone ever exists of any complaint against us by them. A. B, they have to run a park. There can be nothing is because it's earmarked Greenland. And they have been mighty pleased with our work on record. So there was no reason for them to ask us to vacate. Yet by 2018, when it became clear, when the former chairman and the present councillors wrote for regularizing, they offered a PPP. We readily accepted. Then after some time, they again sent a letter attaching some formats to be submitted. We submitted again. Nothing happened. So it became evident that for some reason, they don't want us to continue. And here is what happened. We submitted a timeline. This was not a shanty or a cottage that I could remove in 3 days. We are an organization, my lord, registered charitable trust, registered with Home Ministry for FCRA, registered with the Income Tax Department. So we also have to follow due process of issuing tenders. Removing these assets would mean 2 to 3 months of unceasing work, unbolting, unwelding the whole thing. So we begged them to give us time of 3 months. We submitted a timeline date-wise. In fact, we removed the signboard. We put up the notice that the park is closed. And yet they came and sealed the park. Now, my lord, on the one hand, they sealed the park and keep it sealed. They did not give us 3 months, but they kept the park sealed for 16 months. Proactively, We submitted to them 3 letters.
Mr. Jawar, you submit your arguments. You are going on the right path, but don't get emotional. If you get
However much I try, my lord,
if you
but
become
all the memories of blood and sweat coming off these hands
No.
sometimes troubles
if
me.
you get emotional,
I understand.
you said you were doing yoga here, correct? So if you get emotional, it will affect your health.
I'll try and take long, deep breaths, my lord.
Be at ease. Don't get emotional, right?
I respect your direction, your lord, and I know
Not
that
a
it is in
direction.
my interest.
No,
It's
it
in
will
my
affect your health.
It is my interest, my lord.
We do not want you to, this case or this cause should not affect your health.
Thank you, my lord.
You want water?
May I have a little?
Yes. Take care. Sit down for a moment. Sit down.
Profound gratitude.
Sit down for a minute. Sit down for a minute. Yes, Mr. Jawar.
My unbounded gratitude, my lord. My lord, the memory of the sacrifices of hundreds of volunteers and donors, volunteers from various universities from all over India, that comes to haunt me when I'm reminded of the brutal bulldozing, of merciless bulldozing and needless. It was as if it was enemy territory. It was all pulled down. And my lord, what? Without notice. I repeat this, my lord, when they came to seal the park, right at the time they came to seal, they found our staff vacating the park. We were packing. They acknowledge it. And this is a fact. Even then, they sealed the park. So, my lord, at law and morality both, what happened? We were prevented from vacating. This point, I beg to submit, has serious legal implications. They physically prevented us from vacating.
What is this part?
Beg your pardon?
What is this part? S-P-R-A-T?
SPRAT. S-P-R-A-T expands to Society for Promoting Rationality. And if I may be permitted the indulgence of 1 minute, I may explain what this is about. My lord, this society was set up, co-set up with Dr. Y.K. Alag, Dr. I.G. Patel, etc. by me in 2002 to promote rational thinking, which in my evolution of rationality, understanding of rationality from the second-hand book bazaars of Hyderabad,
how do you expand that?
Society for Promoting Rationality. My lord, as I came to appreciate the the importance of rationality, I began to lose faith in the institutionalized religions and temples and mosques. But one temple that I still have faith in is this temple of justice. On trial today is
No.
not only my
Where
faith,
are the bylaws of this? Bylaws or what do you call?
the
You have
charter,
It's a trust.
it's a registered charitable trust and society, my lord. It was awarded.
No, it
national-
can't be both.
Yes, my sir.
It can't be, either it can be a trust or
No,
it can
my
be a.
lord, in Gujarat, under Bombay Public Trust Act, they
Correct.
register both as society and trust. It's and both come under the jurisdiction of the Charities Commissioner. The societies, the certificate of registration is attached.
No,
my
where
lord.
are the bylaws of the society? Bylaws or what you call regulations?
It's a very comprehensive one. It was not attached, but we
Oh.
can submit it. But the certificate of registration is attached, my lord.
No, can you make available the
Yes, ma'am.
objectives of the trust?
Yes, my lord.
Huh?
Yes, my lord. And this is a very clear objective. This was, as a matter of fact, we were running across Gujarat, multiple centers of empowerment, largely through using education and livelihood. These were funded, supported by government of United States and the Ford Foundation, ONGC, BSNL, etc. But we were advised that pursuing harmony is best done by engaging people through recreation. Therefore, we approached ORDA. Now, when we approached ORDA was looking for someone to do the park because for 30 long years, they had not been able to build this park. It was a communally sensitive area. Therefore, my lord, when you found me emotional, this is where it comes from. I sat down in a tenement for 3 months doing Gandhigiri, eating their food, making friends with Hindu and Muslim people, winning their confidence and trust. And that is how this park came to be. Anyway, so when they came to seal the park, we told them we are already removing.
12:45, we will stop, right? We will continue on the next date.
Yes,
So
yes.
that
Yes, sir.
we have fixed another matter at
Yes,
12:40.
yes, my lord.
Right?
It's an honor. It's a privilege. In 3 minutes, I'll.
All right.
When they sealed the park, my lord, we then approached then commissioner. I wish you were in Ahmedabad then, my lord. Mr. Vijay Nehra was appointed as a new municipal commissioner, a person praised to be for his dynamism. We approached and we explained. And we said, sir, we want to vacate the park because they have sealed and they don't want us anymore. He studied, he talked to the deputy commissioner and the garden people on telephone. We don't know what conversation took place, but he said this: do not vacate the park. You don't need to vacate the park. In fact, we will allot 2 more pieces of land on the riverfront. We want you to set up science popularizing facilities. You are doing wonderful work. You are a nationally awarded NGO, blah, blah, blah. I said, sir, that is what you say, but the people down below will continue to threaten us. It has become distasteful. He talked to the deputy and said, don't do anything until I visit the park. And he told me, Mr. Johar, we'll visit the park. We had been a delegation of 3 NGOs. 4 weeks later, he was transferred. We waited for a couple of months. We thought the commissioner's word would reflect in some notings in the file somewhere, but nothing happened. So we wrote proactively. The park remained sealed, but we approached the authorities to unseal the park and allow us to vacate. 3 communications duly acknowledged. My lord, every single communication that I say.
Which are those communications?
The communications, my lord? Yeah, may I take them? Because there are whole, 5 or 7 other papers that I wish to point out to you. May I be permitted to finish this?
Yes.
Sentence? Thank you, my lord. Thank you very much. So the communications clearly offered to vacate, requested, begged them to permit us to remove our belongings. My lord, on 4th June, my neighbors called me to say that the park has been demolished, bulldozed. We again wrote to them, allow us to at least salvage our precious, because there were documents, there were hobby centers, there were DVDs, the encyclopedias, because it was multiple things. They would not, they did do nothing. Instead, what they did, my lord, is this: they crumpled, broke, cut. And now when they say, come and collect your goods, my lord, there are no goods that they recovered. These are, in fact, what is lying there is scrap. And if I may be permitted, these are the photographs of last week, if I may.
Whatever you give to the court, you should give it to the other side also.
Here it says, right now. And some glimpses are given on page number 163, also in black and white. This is what lies of the park. And you know, my lord, I want to draw distinction between removing the asset and destroying the asset. I suppose, my lord, the term remove implies retaining reusability of an asset. I beg to submit again that the maximum power that they have in case we violate it is remove.
These things are lying in Buddha.
So my lord, they find no fault with our work for all of 17, not 13 years, but even to date they found no fault with us. Number 2, they have to do nothing but run a park. Number 3, as may all the connected corporators have recommended that we continue. Number 4, we have impeccable credentials, not only from AMC. The fact that the mayor himself offered 2 more pieces of land, that we have otherwise also impeccable credentials. No allegation of any wrongdoing has been done in terms of secularism, in terms of dedication, selflessness. At the end of it all, my lord, who profited? They saved crores of rupees worth of money in building the park and maintaining and running and supervising and taking the risk of user injuries. All of that was borne by us. At the end of it, what we got is this brutal destruction of all our life savings without allowing us to retrieve repeatedly 3 long years our notices, our communications exist. My lord, I mentioned to you that we were running these educational centers. These were also in leased lands given by private people for limited period, and we vacated them one by one. Therefore, my lord, we bought a piece of land in Mathar. Mathar is about 40 kilometers from here, our own piece of land, to set up our own permanent facilities rather than be dependent on the government. So we requested the corporation to help us with their JCBs, trailers, to transfer, because these were large trusses, they can't be accommodated in trucks. And Mr. Nehra said, I'm asking you not to vacate. Nevertheless, if you really want to vacate, I'll arrange that. We begged them because we had to float tenders. This is a huge amount of money, 5 lakh rupees worth the cost of transportation, my lord. Therefore, we could not vacate. You know, without all their notices of the last 2 years, give us 3 days. I repeat, it might sound ridiculous to you. How could they ask us to do such a thing in 3 days?
Continue on next state. Third, Mr.
Jauhar.
What Jawahar? Your full name?
Hassan Jauhar. Please call me Jauhar. This Mohammed Hassan
Mohammed
Jauhar.
Hassan Jawahar. Appellant party appearing in person in LPA 434 of 2022, who is also respondent number.
The only respondent.
And representing the respondent, sole respondent in LPA 193 of 2022. For further hearing, list on 18th. On 18th, you come at 4 p.m. We'll hear you on that date.
Thank you so much.